Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 44 of our Lakshmikant series Kanthas. I hope your preparation is well on track. Today we are going to discuss judicial activism. The word simply means that judiciary is going to work as an activist. It means for larger good of society, judiciary may sideline the set precedents. Here the word precedent represents the boundaries which are set by doctrine of separation of power. As you know, legislature is there to make law, executive to implement law, and judiciary to adjudicate, to resolve conflict. Now, if legislature loses confidence of the people, means not making laws which people need. Executive loses confidence due to poor administration. Now, can there be a stable system if people are not having confidence in these two important pillars? No. Now, what choice judiciary has? To remain in boundary or to step up? What you suggest? I think you would say, so judiciary should step up in this situation, if situation is such at least. Right? So in this case, when judiciary step up, then we call it judicial activism. Judiciary may pronounce some judgments which are actually considered as encroachment into the work of legislature or executive. Okay? Now this term was first coined in USA. There was one article, The Supreme Court 1947 Fortune magazine. Although this term actually got applied in India in 1970s, and there is a specific reason to that. Because first 2 decades after India's independence, Congress was having huge legitimacy in the eyes of people. And that phase of India's judiciary is considered as pacifist phase. Judiciary was agreeing with what executive was saying. But then things changed. Let's start with one question. Who among the following is associated with judicial activism in India? Answer is all 3 judges. Now, meaning of judicial activism, you should remember, judicial activism is there for protection and expansion of individual rights. Protection and expansion. And for that, judiciary depart from the set precedents, as I told you, established patterns. And sometimes it is considered that it is like intrusion into the legislative or executive matters, right? So these 3 key points you should remember. Now just attempt this question. Which of the following is an outcome of judicial activism? Please remember, question is not saying which of the following is related to judicial activism. It is saying outcome. If it says related, then answer would be different. Outcome. Judicial review, public interest litigation. Answer is public interest litigation. Because the public interest litigation is actually manifestation of judicial activism. Clear? Judicial review we discussed in the previous video. Now, the concept of judicial activism, and as I told you, that if it is saying related, then answer would be different. Because judicial review is also used for judicial activism. But it is saying outcome of judicial activism. Outcome is not judicial review, right? The concept of judicial activism is closely related to concept of PIL, as I told you. PIL is like a tool, one tool of judicial activism. Apart from the reasons which I have just mentioned, like failure of legislature or executive, there are others as well. For example, judicial enthusiasm. It means judges like to participate in the social reforms. It encourages the public interest litigation, and it happens due to the relaxation of principle of locus standi. It means even if you're not party to that particular case, but for larger public interest, you can take up this matter before judiciary. You can take example that when it comes to some social evils in our society, so legislature is there to make law regarding this, that these evils are prohibited and this is going to be punishment. But if there's a situation that legislature is not doing anything in this regard, and someone actually filed a PIL in court, so now judiciary can actually use the judicial enthusiasm and be part of social reform. Judiciary can prohibit by its decree that this social evil is prohibited, right, and punishable. Then legislative vacuum, it is connected to this. It means if legislature has not made the law and there is a requirement, then judiciary can step up. The Constitution of India has also given enough scope for judiciary to actually work in this manner. means to legislate on these important matters. When I say legislate, it means it's not like judiciary is actually making an official law, bill. No. For example, the judgment of Supreme Court, because Supreme Court is court of record, has power that it is going to be applied as a precedent, right, by other courts as well. Now, activators of judicial activism. According to Mr. Upendra Bakshi, we can categorize them in these following headings. 1. Civil right activist. It means there may be some activists who are demanding some civil and political rights. So this is one section where judiciary work as judicial activism, uses activism. Then people right activist, here we talk about socio-economic reforms. For example, there's a PIL for, say, farmers. Farmers not getting their due. Payments not given to farmers for their sugar cane, which they have already given to some sugar mills. So judiciary can actually intervene here, although this function is of executive. But for the larger good of society, these poor farmers, judiciary can intervene there. And it will be considered as an economic right. Consumer right groups. For example, judiciary is saying that these particular brands has to give this detail. These details should be published before you present this product to any consumer, right? It means labeling, etc. Any law regarding this, it will come under consumer right groups. Citizens for environmental action. In past few years, if you have seen, especially with regard to the pollution in Delhi NCR, our Supreme Court has acted, in a wide variety of manner, right? Supreme Court has established a dedicated commission who actually also coordinate with Delhi, Haryana, Punjab, specifically on this matter of pollution near Diwali, right? So environmental action. Rights of child groups. As you know, that child are the least represented group of a democracy because they don't have the age, they don't have the say, right, vote. So in this regard, judiciary has intervened. So if activists bring this point to judiciary and judiciary work in this regard, this is one section. Then women rights groups, for example, Vishaka guideline, for example, judiciary interpreting sexual harassment laws. Assorted lawyers. It may be possible that some dedicated influential lawyers, they also influence the point of view of judiciary on a particular important matter. Now, judicial activism versus judicial restraint, there are two words. Activism and restraint, and these are opposite words. Restraint word itself represents that judiciary is setting a limit on its own action. This judicial restraint word has been used by our former CJI also. For example, Mr. R.M. Lodha, in his farewell party, he was saying that judiciary should use judicial restraint moreover and judicial activism rarely. Now, what is this? In judicial activism, judiciary loosely interpret constitution. Loosely, it means judiciary actually increases increases its power by interpreting constitution. But when it comes to judicial restraint, it is a strict interpretation. It means judges should follow the precedent. So when judges follow the precedent, it is judicial restraint. When they set aside precedent for the larger good, that is judicial activism. Now, assumptions of judicial restraint. So now we are going to talk about assumptions which are used in USA. Okay. So in case of USA, and this is very much applicable everywhere, that they say that judiciary should actually use judicial restraint, not judicial activism, because judiciary is not an elected body, right? In democracy, faith of the people is in parliament, legislature, and thereby executive, right? So undemocratic, non-elective, non-responsive to the people. That is why they should not encroach upon, into the powers of legislative and executive. Origin is also, discussed that it is questionable, not specifically granted by the Constitution. The way it is acting means activism is not granted by the Constitution. It is due to the loose interpretation of judiciary that judiciary has given itself this power. Doctrine of separation of power is being compromised due to this. Concept of federalism. Take example of USA. When it comes to federal and state, they have different laws. It may be possible that federal law is totally different on that particular topic and state law is different. And you know that concept of federalism is quite strong in case of USA in comparison to India. So dividing the powers between the nation and the states require the court deference. Means court should also uphold this. Means court should not actually intervene into the state government and its officials. Non-ideological but pragmatic assumption that since court is dependent on the Congress we are talking about US, House of Representatives, because court is dependent on Congress for its resources, right? So in this manner, that court should actually limit its power because they are also dependent on House of Representatives, on public acceptance for its effectiveness, not to overstep its boundaries, right? So this particular point is based on this fact that law is based on reason, and reason represents reason of people, faith of people. When people accept you, then only you can be effective. So judiciary should not surpass that boundary. Then being a court of law, custodian Anglo-American legal tradition, law being a process of reason and judgment. So it represents that legal precedents are also having social context, and judiciary should also take into consideration this. It is not like if some courts in the world are using the judicial activism in this manner, so you also do this interpretation in context of your country. Now, it was of USA, assumptions which USA has with regard to this. Now, what our Supreme Court has observed. Now just see, Supreme Court has said that judicial restraint should be used. Judicial restraint and ask courts to take over the functions of legislature, or should not take over the function of legislation and executive, should not encroach into this. So it is with concern to the bench that they should uphold this particular principle, because if they encroach into legislature and executive, then it actually gives an image that the system is not balanced. And if judiciary is getting strong and legislature and executive are getting weak, this is not good for country. Some people may say what we want is good. If judiciary is doing that, then what is the harm? There's a harm. Because if a law is there which is made by legislature and you're not happy with that, you can change that particular party in the next election, right? You can give them a message, but same cannot happen with regard to court, right? And if you don't follow the decision of court, then it actually is a question on legitimacy of court. That is why balance is necessary. Trying to perform executive and legislative functions is clearly unconstitutional. Constitution has not said that you perform legislative and executive function. And on this point, you can also remember, consider the example of coal scam. In coal scam case, Supreme Court actually, in coal scam as well as in this telecom scam, this 2G spectrum scam, court by its judgment said we are actually cancelling these licenses. So cancellation of license could have been an executive action by the respective ministry, but court did that. Now, a point on this is that court is not well versed with the market dynamics. Court is not well versed with the ground reality, because court is not having department working on ground, but executive has. So executive has more experience, practical experience. That is why if court perform such actions, it may be having some ramifications in that actual market or on the ground. That is why it is unconstitutional to work in this manner. Judicial activism must not become judicial adventurism. It should not be like an adventurism. Restraint should be there, and minimization of judge preferences. I mean, there should be some standards which need to be upholded by every judge. It should not be an adventurism. Judges must know their limits and must not try to run the government, because running government is not your job. They must have modesty and humility. They should not work as an emperor. Now, judicial restraint is actually complementary to the balance of power concept. There should be balance of power. Judicial restraint not only recognizes the equality of other two branches, means legislative and executive. These are the positive points of judicial restraint. It also fosters that equality by minimizing inter-branch interference in the judiciary. Because if you interfere in legislative executive, then it may be possible in future they will intervene. So it is also a threat. It may also turn into a threat to this independence of judiciary concept. So judicial restraint tend to actually protect independence of the judiciary. So if they set their limits, then other will also set their limit. This is how practically system is acting. Now let's attempt this question. In recent time, judicial activism comes in news frequently. Judicial activism can be said in action in which of the following cases? Legislature, executive wings of the government fail to discharge their duties under Constitution, Supreme Court intervenes. It is correct. This is the basic definition. High Court intervenes through appeal against the judgment of lower court. No. Here, judiciary is taking appeal from the lower court. This is not correct. A court monitors the development in a case during the period and issues necessary direction. It is also correct. So it means answer is 1 and 3. It means C is correct. So I hope now you are clear with this idea of judicial activism. This PDF is going to be available in Shashank Tyagi for you Telegram group. If you have any doubt, you can shoot me a message on shashank.powerbeing. That is my personal Insta handle. Take care.